Thank you for taking the time to be here today. We're so happy to have you guys with us. I'm Haling Ortega, Pro Bono Coordinator here at Legal Aid of Arkansas. I'll be your moderator today. We're also joined by our Pro Bono Director, Casey Copeland, and he'll join us a little later, offering some closing remarks. Before we begin, just regular housekeeping. Today's session is being recorded. And then following the program, you'll receive the certificate of attendance, your evaluation forms, and we'll also provide you with a copy of today's CLE presentation. And with that, it's my pleasure to introduce today's speaker, Kendall Llewellyn. Kendall directs a fair housing project at Legal Aid of Arkansas. In this role, she supervises legal work for housing testing program and community outreach. She also carries her own caseload of fair housing cases in state and federal court and before administrative agencies like HUD and the Arkansas Fair Housing Commission. Kendall has served in a variety of roles throughout the years and all of this for Arkansas Public Interest Law providers over the past 12 years. Before legal aid became a statewide program, Kendall managed housing advocacy for Center for Arkansas Legal Services for almost 6 years. Kendall is also a proud member of the Arkansas Access to Justice Commission, the City of Little Rock Land Bank Commission, and Arkansas Trial Lawyers Association. She earned her JD from the Bowen School of Law in Little Rock and BA from Hendrix College. Kendall, thank you so much for being here today, and I'll turn it over to you.
Thank you, Haling, and thanks everyone for spending your lunch with me today with us. So I'm going to give you all just a general overview of fair housing law today. But I'll start off by telling you a little bit about Legal Aid of Arkansas. If you're here, you've probably heard of us before, but what we do is we fight for equal justice for low-income people and communities, and we try to work to fix the conditions that hold them back in life. So we focus on four main priority areas of law: domestic justice. Primarily, we advocate for survivors of domestic abuse. We do consumer protection. We work on housing issues, keeping people housed and, expanding housing opportunities. And we also work on economic justice, which generally means helping people get and keep public benefits that they're legally entitled to, like Social Security or veterans benefits. And if you or anyone you know wants to apply for our services, you can call our helpline at this number here on the screen. And we also have an online application. And we have attorneys who staff the phones 4 days a week from 9 to 11 and 1 to 3. We also take some intake calls, I believe, on Tuesday nights for those who can't call during the traditional workday. And all of our services are free. Within Legal Aid of Arkansas, I work on a project called the Fair Housing Project, which is it's pretty unique within a legal aid program. So what we do is we try to eliminate housing discrimination and guarantee equal housing opportunities for everyone, Arkansans in particular. And we do this a few different ways. The main things that we do are education and outreach, investigation, and enforcement. So on the education and outreach side, we'll go around the state and give presentations to housing providers, to housing authorities, to landlords associations, to all who need to know about fair housing law, because ultimately we just want people to follow the law. We would rather not end up in court if we don't need to. So prevention is important. And if you would ever if a group you're involved with would like for us to come out and talk about fair housing law, we would probably be happy to do so. Just let me know. But unfortunately, not everyone does follow the law. And so we have a team of investigative staff and attorneys. We're a small team, but we investigate and enforce fair housing laws. We are not a government agency. We're housed within a nonprofit. So, yeah. Today, we're going to talk about a few things. First, I'll explain people's general rights under the Fair Housing Act. Then I'm going to talk about how private attorneys can get involved to help enforce the Fair Housing Act. There are a lot of different ways that they can help. Primarily, I would love to see more private attorneys take fair housing cases, either through referrals from Legal Aid of Arkansas or just on their own. There are a lot of benefits to these cases. They are important, they are interesting, they're fun to work on. You can also recover attorney's fees for a prevailing plaintiff. And I'll give some examples of what successful fair housing cases might look like in terms of damages and things like that towards the end of the presentation. But first, I'm going to start with like a legal foundation just for what fair housing rights are. And it's important to keep in mind that the Fair Housing Act, which is the main law we're going to be talking about today, it is just one of many, many civil rights laws, and it has to be thought about in that context. Initially, when I was planning this presentation, I struggled a little bit because I was thinking, if I'm going to explain fair housing law, I'm going to have to talk about all of this. And I just decided that that was not going to be possible in a 1-hour CLE. So today we're going to talk about the Fair Housing Act, and I will talk a little bit about how it intersects with some of these other civil rights laws. And I included this slide for reference. And Arkansas has some of its own laws that protect, the right to fair housing on top of the federal framework. But please keep in mind a couple of things. That if there's a conflict between federal and state law under the supremacy clause to the Constitution, federal law is generally going to control. And also, just because something might be lawful under the Fair Housing Act doesn't mean that it's lawful in general, because it could still violate a different civil rights law. Now, with that in mind, I'll talk a little bit about the Fair Housing Act. The Fair Housing Act is a very historically important federal law that bars discrimination based on 7 protected classes when it comes to housing transactions. And so first, I'll explain what the protected classes are, and then we can get into what kind of conduct is prohibited under the Fair Housing Act. So race, people can't be treated differently based on race or characteristics associated with race. Color means people cannot be treated differently because of their skin color or complexion. National origin means people cannot be treated differently because of where they or their ancestors came from, or maybe because they have some characteristics that are associated with people from a specific national origin group. I think we all know what religion means, but people can't be treated differently because of their religious observances, practices, or beliefs. Sex is what most people would call gender, but people can't be treated differently based on their sex or gender, and this includes sexual harassment. And courts have interpreted it to include discrimination against domestic abuse survivors as well. Familial status, that is a little less obvious. What that means is that people can't be treated differently because they have children, minor children. They can't be treated differently because they're pregnant or they're trying to adopt a child, or maybe they have a child in their legal custody or control. Handicap protection, that just means people can't be treated differently because of a physical or mental disability. And we'll talk later on in the presentation about reasonable accommodations and modifications for disabilities, because that's a huge area of fair housing practice. I would say that the majority of our cases are going to be disability related, and then we see a fair amount of the rest. But right now, I think disability related claims are kind of leading among fair housing groups across the country. The Fair Housing Act bars 9 specific types of conduct when the housing provider bases that conduct based on someone's protected class. For example, a housing provider can't refuse to rent a home to someone based on that person's race. Can't set different terms or conditions for a sale or rental. And they can't advertise a preference or limitation based on a protected class. There are some exemptions that we will get into shortly. None of them are going to apply to advertising, though. Providers can't deny that a unit is available when it truly is, based on, a protected class or characteristic of the person who's trying to get that housing. They can't induce sales of homes through something called block busting, which is sort of when you scare people into selling by suggesting that a certain group of people, usually race, are moving into a neighborhood as a way to kind of trick people into moving and selling their homes to clear up a block. Housing providers can't deny reasonable accommodations or modifications for disabilities, and we're going to cover that in depth later. And it also, covers mortgage lending and other real estate transactions. We generally see fair housing cases involving renters, but it certainly does cover real estate sales, appraisals, all sorts of housing transactions. Something to keep in mind is that you cannot retaliate against someone for exercising their fair housing rights. So say that someone makes a complaint about a potential violation of the Fair Housing Act. Even if that complaint doesn't end up being successful, it's still unlawful to retaliate against that person because they made that complaint in the first place. And we do see a lot of retaliation claims as well. There are some exemptions to the Fair Housing Act, and the exemptions have some limits. They're not a free-for-all. The one we hear about the most is called the Mrs. Murphy exemption, which lets an owner who lives in a building with 4 or fewer units generally, exempt that person from the Fair Housing Act. There's also a single family home exception, which lets a private owner who owns 3 or fewer single family homes at a time, you can rent. Well, they also can't use the services of a real estate broker, but they are going to be exempt from the Fair Housing Act if there are 3 or fewer single family homes and no broker involved. Religious groups can limit occupancy of housing that they own or control to people of their own religion, but they cannot restrict membership based on race, color, or national origin. There are some limits. And there's also something called the private club exception. It has to be a real bona fide private club, meaning it's not open to the public. But a real private club can limit its own housing to members of that club or give preference to members of that club. The lodging itself has to be non-commercial, and it can't be the purpose of the club. The main thing that we hear about with the private club exemption is like sororities and fraternities, which have some social and other purposes beyond just providing housing. But say if you formed a club for the purpose of building housing and it being exempt from the Fair Housing Act, That would not be incidental to the purpose of the club. Word of warning on exemptions. Be very careful with these exemptions. And whether you're a private attorney who wants to do fair housing law or you're a private attorney who represents housing providers, please be mindful of this. None of the exemptions cover discriminatory ads or statements. And as I mentioned earlier, even if certain conduct is allowed under the Fair Housing Act, it can still be illegal under a different civil rights law. For example, the Civil Rights Act still bars race discrimination in real estate transactions, even if the Fair Housing Act may be allowed for an exemption. And the Miss Murphy and single family home exemptions don't protect a housing provider from retaliation claims. So if a provider threatens, coerces, intimidates, or otherwise interferes with someone exercising their right to fair housing, that housing provider can still be held responsible for that, even if they, would otherwise be exempt from the Fair Housing Act. One of the hottest topics in fair housing law today is reasonable accommodations and modifications. I'm sure that you've all heard about service animals and things like that. The general rule for these are going to be if it is necessary and reasonable, the housing provider should allow it. Necessary plus reasonable, then just allow it. But let's define our terms here. What is a reasonable accommodation? What is a reasonable modification? A reasonable accommodation is a change in a rule, policy, practice, or service so that a person with a disability can use and enjoy their home just like anyone else. A modification is a change to the structure itself. It's a change that lets a person with a disability use the unit just like anyone else would. And in general, the person asking for a modification has to pay for the modification. It says tenant there, and I do want to, be mindful of the fact that the Fair Housing Act covers more housing relationships than just landlords and tenants. But we see reasonable accommodations and modifications come up most often in landlord-tenant relationships because, if someone owned their own home or something like that, they wouldn't really need permission to modify it in most cases. Some common examples that we see are, say, a reserved parking spot closer to someone's apartment, permission to keep a service animal despite a no pets policy, or maybe just to not have to pay fees associated with a pet because the animal is not a pet at all. The animal is a tool that helps the person with something related to a disability. Another accommodation we see is a change in the due date when rent is due for people who receive Social Security income based on a disability, so that the due date and the date they receive their Social Security line up and allows them to stay current on their rent and not accumulate a large balance of late fees. For people with mobility issues, a common one that we'll do is we'll ask for a transfer to a ground floor unit. Another one that we see is actually like rescinding or canceling an eviction notice when the reason for the eviction is somehow a symptom of a disability. And I don't mean like non-payment of rent. What I mean is if someone is facing eviction based on behavior or some incident that was caused by an underlying disability, that is something that you can address sometimes through a reasonable accommodation. Some modification examples include like installing grab bars in a bathroom, maybe putting a wheelchair ramp at the entrance of a building, adding lever style door handles instead of like knobs that you would have to turn like this, and lowered countertops and lower light switches that people are able to reach. And I will say that in federally funded housing, which is going to mean most HUD funded housing, like public housing or project-based Section 8, the owner actually has to pay for reasonable modifications. And that's going to be under a different law called Section 504, informally. But just because a private landlord accepts a Section 8 voucher, that alone isn't going to trigger them having to pay for modifications. In general, private landlords, the tenant has to cover the cost of a reasonable modification. Once again, the rule is necessary plus reasonable. If it's necessary and reasonable, the housing provider should just allow the RA or RM, meaning reasonable accommodation or modification. So let's break down, what does reasonable mean? It means, does the person have a disability, and would the accommodation address a barrier related to that disability? So what does reasonable mean? The accommodation can't impose an undue financial or administrative burden on the housing provider. They also can't fundamentally change the nature of a housing program. For example, someone in an apartment complex may need an accommodation, maybe to allow grocery deliveries to their front door, when that otherwise wouldn't be allowed. I think that's perfectly reasonable. What may not be reasonable is if that person were to ask the housing provider to go and get their groceries for them. That's not a real example. None of our clients have ever tried to ask for that, as far as I know. But I just say that, that would be a fundamental change to the nature of the program, because you would be asking them to provide a service that they don't already provide. It's really beyond just housing. The parties need to engage in a good faith interactive process to try to find an accommodation or modification that works for everyone involved. Now, if the initial request is necessary and reasonable, the housing provider still has to grant it. But let's say that the original request isn't reasonable. It would be too expensive or just unworkable for the housing provider for some reason. The housing provider could then propose an alternative that would still meet the person's disability related need, but maybe more practical for the housing provider. And they really need to, engage in a good faith back and forth with the person to try to find something that works for everyone involved. And I would say that just delaying an accommodation or ignoring a request for one, that's going to be the same as denying it in the eyes of the law. And keep in mind that tenants, I keep on saying tenants, I'm sorry. People can request accommodations or modifications at any time. So they'll usually request them when they're applying for an apartment, during a tenancy, or even when they get served with an eviction notice in the example that I gave earlier. And the request does not need to be in writing, although a written request is something that we recommend so that, the parties have a paper trail of what was requested. And I think it's good for the housing provider to also respond in writing to the request, just so everybody has a record of what happened, what was requested, what the outcome was. And for modifications specifically, the housing provider can require that the modification be done well. They can require professional workmanship. So for example, if some modification is something that you would normally need a permit from the city to do by like a licensed contractor, the housing provider can require you to get a permit from the city for a licensed contractor. I've also heard of, sort of like an escrow account or an extra deposit to cover the cost to restore the building to its original condition when the tenant moves out, if the modification is something that would be a problem for future tenants. I don't think most of them would be, though. Can the housing provider ask for verification? They can when the disability and the need for the accommodation or modification are not obvious or something that the housing provider already knows. For example, like say you're a landlord and you rent an apartment to a tenant, or you are about to rent an apartment to a tenant who uses a wheelchair and always has in your dealings with that person. I don't think that it would be reasonable there to ask for like medical verification that they need a wheelchair ramp because you can see it with your eyes. But a provider can ask for reliable information confirming that someone has a disability, the accommodation or modification that's needed, and sort of an explanation of how those things relate to each other. There has to be some connection between the two. The accommodation or modification has to like alleviate a symptom of the disability or help with the disability in some manner. Housing providers should not ask for the person's specific diagnosis or anything that they wouldn't need to know to evaluate whether or not the request is necessary and reasonable. Most of the time, people are going to provide a doctor's note, but it needs to come from some reliable third party. A lot of the time, they'll also come from nurses or therapists who are generally going to be like licensed clinical social workers. Now I'm going to talk about sort of how the Fair Housing Act is enforced and what role private attorneys can play in this process. There are two main routes to enforcement. The first path is an administrative complaint. You can file a complaint within 1 year of the last act of discrimination with HUD or the Arkansas Fair Housing Commission, which is a state agency in Arkansas that investigates and enforces fair housing laws. I will say that you can file both of those complaints online. HUD will delegate some of those investigations to the Arkansas Fair Housing Commission. They're here, they're on the ground, they're closer. But if you are making a complaint under the Violence Against Women Act, those complaints have to go directly to HUD. And there's a whole investigative process that will toll the statute of limitations if someone wants to file a private lawsuit later on. Now, unlike employment law, you don't have to go through the administrative process at all. And some people will just go straight to court, right? There's a 2-year statute of limitations from the last act of discrimination. You don't really have to exhaust your, what is it called, administrative remedies. You can just go straight to court, and you're actually allowed to file a Fair Housing Act case in state or federal court. Normally, if you're going to bring it in state court or federal court, you're going to be bringing claims not just under the Fair Housing Act, but under multiple laws, including the Arkansas, I call it the Arkansas Fair Housing Act, but it's substantially equivalent to the federal law, but it is a state statute. And these cases commonly come up just on their own. And they also come up as counterclaims or defenses within eviction cases, which is sort of an interesting part of doing this project within a legal aid program, because a lot of people do have like actionable fair housing issues without realizing it. So they may not think to call a lawyer or make a administrative complaint or something like that to say, I think that my housing provider has violated the Fair Housing Act. but they may think to call legal aid or know to call legal aid if they're facing eviction or having problems with a landlord. So one of the main ways that we get these cases is by screening people who otherwise call us for just like landlord tenant matters. And we end up picking up quite a few cases that way. Oh, and I forgot to mention that the administrative like investigation process, it's supposed to last 100 days, but it can be extended when there's a good reason to do so. And so say someone goes through the administrative process, the agency is going to make some kind of finding, whether there is cause or no cause to believe that a violation of the law, fair housing law has occurred. And then they're either going to go to some kind of administrative hearing before one of those agencies, or in Arkansas, the Attorney General's office would file a case on behalf of the Arkansas Fair Housing Commission. And then we would usually intervene on behalf of the complainant in that case. That's a little bit different. When these cases are brought in court, there are, some pretty good remedies for successful plaintiffs. A court can order the housing provider to stop the discriminatory conduct. They can grant injunctions. In an eviction case, they could deny a writ of possession or dismiss the case. A prevailing party, well, a prevailing plaintiff can recover actual damages, and that does include emotional distress damages, although they of course have to, prove those. A prevailing plaintiff can also recover punitive damages against a housing provider who, acted with malice or just like reckless indifference. There can also be civil penalties. Generally, those are going to be fines and fees paid to the government within administrative cases. But there can be some pretty large civil penalties. And plaintiffs can recover their attorney's fees and costs. So I would, encourage any private attorneys on this training to consider if they may want to take some of these cases. If we were to refer a case to a private attorney through our program, if they prevailed in the case and recovered attorney's fees, they could keep those fees, although you couldn't charge the client anything up front. That's just how our program operates, though. But if you wanted to take these cases on your own in your own private practice, you could structure it differently. Generally in Arkansas, there aren't really very many private attorneys I'm aware of who take these cases, but I think there is some opportunity to do good work there. And I also, if you're a landlord's attorney or something like that, I hope that this presentation can help you advise them appropriately about how to comply with the law. I'll give you a couple examples of Eighth Circuit cases so that you can see what some of the remedies are like. Quigley versus Winter is a sexual harassment case in which Miss Quigley she rented a house from Mr. Winter. She had a Section 8 voucher. Mr. Winter, he touched her non-consensually in a sexual manner. He showed up unannounced at night, made unwelcome comments about her 14-year-old sister, and made comments suggesting what we call quid pro quo, which is when you exchange money for housing. Sorry. No, it's when you exchange like some sort of sexual activity for housing. That's generally going to be considered quid pro quo sexual harassment, which is actionable under the Fair Housing Act. So Ms. Quigley sued for sexual harassment. using both a hostile environment theory and a quid pro quo theory. And she won. The jury, found for her. She got over 13 grand in actual damages and 250 grand in punitive damages, which the court reduced the punitive damages award. It was appealed, and the Eighth Circuit, agreed with the jury on liability findings, and increased the punitive damages to almost $55,000. And the attorney's fee award was about $78,000. 78, yeah. That isn't, I wouldn't say that that is a typical damages award in a fair housing case, but that is kind of the range that we're talking about here. This is an example of how fair housing laws come into play in eviction cases. So, the Fair Housing Act, it can be kind of a shield and a sword when it comes to eviction. What we see a lot in these like state court level eviction cases is that it'll be raised, by us, as both a defense if we're saying this is actually just a pretext for illegal housing discrimination. It'll be raised as a defense, but it could also be raised as a counterclaim within that case. Procedurally, this case was a little bit different, but a tenant with chronic depression asked his landlord for extra time to clean up his apartment because he was ill. The landlord gave him an eviction notice. The tenant, eventually told his landlord that the illness was disability related. It was kind of at the 11th hour. It was the day the eviction notice expired. And I think the tenant ended up moving out without a court order to do so, but later sued in federal court. And the landlord initially won summary judgment. The court reasoned that the landlord didn't know about the disability early enough. And the Eighth Circuit reversed and held that, the landlord did know, and that as long as the landlord knew by the time that before the person was actually evicted, that's enough, not just the date of the eviction notice. And the case got remanded for further proceedings. So unfortunately, I can't really tell you what the outcome was in terms of damages and things like that, like in Winters. But I hope that this kind of paints a picture of how these play out in eviction cases. So with that, I want to talk a little bit about how you can get involved. We are actually recruiting for a staff attorney, a full-time staff attorney at Legal Aid of Arkansas who would work on fair housing cases. You can apply online. We also have a testing program where we hire people to essentially apply for housing opportunities, and report whether or not they experience potential violations of the Fair Housing Act, which we can then take legal action on. And also you can become a pro bono attorney through our program, and we will refer cases to you. I think that Casey may have some things to share about that. He is our pro bono director.
Anyway, my name's Casey Copeland. I am the pro bono director here at Legal Aid. My job, like Kendall said, is to find private attorneys to help us out with some of the cases that we just can't get to because we don't have the capacity. We don't have enough attorneys. We don't have enough staff or resources to get to everybody that calls us. So pro bono does that. Currently, I looked just this morning, we have 61 cases that we're trying to find homes for, including 3 housing discrimination cases. And we expect that number to go up quite a bit as more come over from the housing work group. But as you can see, we've got cases from debt collection and wage issues all the way to Social Security cases, guardianships, family law, and of course, some landlord, tenant, and eviction type stuff. We have a number of cases at any time in any of these areas and a few others that may not be showing up here. Um, If you take on a case for extended representation, you get some support from Legal Aid of Arkansas, including access to our attorneys, access to our staff, sometimes access to our facilities and offices if you need that. We can also help with some out-of-pocket expenses as far as litigation costs like filing fees. Although most of our clients are going to likely qualify for informal pauperous approval and get those fees waived, and we can help you with those documents in that process as well. Some travel expenses, of course, our CLE program. So a lot of different resources and things that we want to offer our pro bono attorneys, so that you kind of feel like when you take one of our cases, we're just an extension of you and you of us, and we're working together, and we want to help make that case go as easy as possible for you. Um, Other ways to volunteer are through legal clinics. We've got legal clinics coming up all the time, including a pretty big record sealing clinic coming up in Wynn in September, Hot Springs next week. So we have a number of different clinics going on at any time. Most of our clinics are record sealing or estate planning, but we do some comprehensive clinics and some family law clinics from time to time. And if you're with a group that wants to have a clinic, if your firm or maybe your corporate legal and you want to do a clinic that is focused on or just for your folks, we'd be glad to talk to you and get that set up and make that happen. We will help you at the clinics. We've got forms and templates, access to printers and notaries and witnesses and all the stuff that you need to come in and prepare and execute the documents that might be prepared at those clinics. We can provide that, and we will help get you ready for that, including, access to those forms beforehand. We'll do little training sessions before those events. We'll do a little refresher, kind of like here at lunch. We'll sit down and we'll talk about estate planning issues or record sealing issues, whatever it might be. In fact, we also have another CLE coming up September 25th with Drew Rogers. We'll be talking about debtor-creditor issues. We don't have our flyer ready for that one yet, but there's the QR code to register for it, and we can send that out as well when we get closer to time. But Drew's going to talk about like debt collection, garnishments, bankruptcy, a number of different things that are involved in our debtor-creditor clients here through Legal Aid. Of course, I'm always available if anyone has any questions about pro bono opportunities or assistance with a case. We've got pro bono coordinators in Springdale and Jonesboro, and another one about to start in Little Rock. And you can feel free to reach out to any of us at any time if you have questions about legal aid or the opportunities that we've got available, or cases that you may be working on and you need assistance with. Now back to what Kendall's talking about. Um, you know, we are, most people don't know this, but maybe you do. Before this year, Legal Aid only had 31 counties in North and Eastern Arkansas. This year, we've expanded statewide to 75 counties. Our Fair Housing Project has been involved statewide for some time. But we're in a transition mode. We certainly don't have enough attorneys to take on every single case that comes to us. And a lot of these cases, or all of these cases, deserve some individual attention from attorneys and help these people deal with whatever the discrimination issue that may be going on. So we just can't reach all of them with just Kendall and her group. And we need help from private attorneys. And if it's something you've not done and you want to try your hand at it, I know that Kendall and some of her attorneys would be happy to walk through those cases with you, serve as co-counsel with you, provide, brief templates and pleading templates and whatever it is to assist you with that case. And maybe you'll find out that, it's something that you really enjoy doing and you want to do more of. Or maybe like me, when I did bankruptcies in private practice, maybe you don't want to do those anymore. But if you have the opportunity and the inclination, we would encourage you to try one of these cases and let us help you get through those. And again, I know our slide here just said we had 3 cases, but Kendall, how many cases does your work group have going at any one time on fair housing issues?
I think I ran a report yesterday, and across the organization, there are about 100, maybe.
Okay. And how many attorneys are in your work group doing this work?
Well, that includes more than just in our work group.
Okay.
But right now we have 2 attorneys in our
Okay.
work group.
So two
And
attorneys in
great
fair
support staff.
housing trying to wrangle 100 cases, and that caseload is growing all the time. So this is one of those things that, we desperately need some help from the private bar, and we want to help you help us. So that's part of what we're trying to do in the pro bono department, Kendall's department. Kendall, anything else I can say to help you out?
No, thank you very much,
Yep,
Casey.
sure.
And yeah, like Casey said, we'll be happy to co-counsel and kind of walk you through these cases. I would love to do that for anybody who's interested. Some of them could be litigation cases. Some of them could be administrative cases that you file with HUD or the Fair Housing Commission. Or if you're, you don't even want anything that adversarial, you could just try to negotiate a reasonable accommodation for someone or something like that, completely outside of court. There are a lot of different opportunities.
Haley, I apologize. I did have a message here that I wanted maybe Kendall to comment on. I know you talked about attorney's fees in these cases.
Mhm.
What is fee shifting? What does that mean, and how does that apply in these cases?
A prevailing plaintiff in a Fair Housing Act case can recover reasonable attorney's fees and court costs. Actually, I think that they have a very good attorney's fees, well, a very plaintiff-friendly attorney's fees law, because I believe the defendant can only get attorney's fees if the case is like frivolous. So it's not just the prevailing party, gets attorney's fees.
And even though we have these cases and we're referring them out for pro bono, those attorney's fees are still on the table. It's just like, Kendall can win a case and collect attorney's fees for legal aid. If you take a pro bono case and win and recoup the attorney's fees, you can retain those as well. So it's not like, it's not like a divorce case or a guardianship case where you're doing it just purely without any hope of any kind of income or fees on it. These potentially have that built into it. Thank you, Kendall.
We just want to thank everyone for joining us today. Encourage you to stay connected with us. And on behalf of our team, thank you so much for being here today and have a wonderful afternoon.